Welcome back. We're going to start section 2 now of designated agency meeting consumer expectations. Doug, tell me, what is the main difference between brokerage practice under common law and designated agency?
The main difference is where the agency relationship exists between the brokerage, the industry professional, and the client. In a common law brokerage, the agency relationship is with the brokerage, and everyone at the brokerage works for all of the brokerage's clients. This may create conflicts of interest, such as when the brokerage represents two parties in the same transaction, when two industry professionals of the same brokerage are representing their respective clients in the same transaction, when one industry professional is representing both the buyer and the seller in the same transaction. These conflicts trigger the brokerage to act as a transaction facilitator, provided there is timely and informed consent by the clients. Under designated agency, the agency relationship is between the client and the designated agent, not the brokerage. The service agreement is between the brokerage and the client. The potential for conflicts of interest is reduced under designated agency, as the buyers and sellers can have sole agency representation in the same transaction using different associates. When two associates within the same brokerage represent the buyer and the seller, they will treat each other as if they were registered with different brokerages. We asked a broker how she felt designated agency would affect buyers and sellers.
I think that with designated agency, there's huge advantages for the consumer and the customer, and then also the benefit to the associates. So when I think about the consumer, when they start a relationship with their realtor, they expect to have that relationship go the whole way through. And when you get into a transaction brokerage type situation currently in common law, we have to start to remove ourselves and not assist them anymore. And I think that's a big challenge for the consumer to totally understand. I also think when you're dealing with two different associates within the same brokerage, there's a concern that the consumer expects you to represent them, and right now under common law we're finding that they don't understand that change and that the information isn't shared. But the realtors have a hard time pulling themselves back from representing somebody that they were fully representing before. And I think that so it'll allow the realtors to continue forward and fully act for their client and work for them. And I think it also benefits the realtors from being able to move forward in that transaction. So there's a huge benefit to both parties.
So who are you referring to when you say designated agent?
Designated agent refers to the specific industry professional or professionals that have been designated by the brokerage to represent a buyer or seller client. A designated agent can refer to a single industry professional or a team, where all the members of the team may be designated to act as one.
Does that mean in a designated agency brokerage there are fewer instances of transaction brokerage?
Yes, there are fewer instances where a conflict arises, which I will demonstrate with some statistics later on in this session. It also provides for more options when a conflict does arise, such as acting as a transaction facilitator with consent, treating one client as a customer with consent, referring one client to another industry professional within the same brokerage, or referring one client to another brokerage.
So is it the reduction in the number of conflicts that might be the main reason a brokerage would consider designated agency?
Well, it's one of the main reasons, and as I mentioned earlier, most consumers already believe that to be the case. Here is a video clip from an associate who is a team leader at a brokerage already practicing designated agency. He makes a few observations of their experience.
I think the most interesting element of the change was the consumer's reaction when we explained our change to designated agency as a brokerage. The most interesting response that we've had, and the most common response across the board, has been that the consumer figures that we're operating real estate like this anyway. They figure that the relationship between a buyer and a seller is between the buyer and the seller. We, representing the buyers, come in representing solely that buyer, or we represent the seller solely as the seller's representative. That reaction has been the most interesting part of the change. It's really been a thought process from the consumer that's the way real estate operated anyway.
In practical terms, Doug, how is designated agency different?
For the most part, not a lot changes from what industry professionals do today in their day-to-day dealings with consumers. Who is the designated agent in your brokerage today for a listing? In practice, the listing agent is the only person at the brokerage who truly knows all the details about the property and the personal circumstances of the seller. Who is the designated agent in your brokerage today for the buyer? In practice, the only person at the brokerage who knows the needs of a buyer and their personal circumstances is the industry professional working with that buyer. Here is a video clip of Brian Taylor, legal counsel for the British Columbia Real Estate Association, who was very involved with agency changes and the education in British Columbia, explaining what designated agency is.
Designated agency is really a process whereby the brokerage designates an individual realtor to act as the sole agent for a buyer or seller for a client. If you think that generally what we have now is the brokerage enters into the contract, and if the brokerage says that they're going to be agent, then all of the realtors in that office are the agent for the buyer or the seller. So what designated agency intends to do is we're trying to, and when all the realtors in the same office act for the buyer or the seller, an individual client, conflicts arise because they're deemed to know everything about all these clients. So what we're trying to do in designated agency is to download what I would say the obligations, the duties of loyalty, disclosure, and confidentiality down to the individual realtor. So only one realtor will be responsible for confidentiality and disclosure and loyalty to the client. Other realtors will have their own clients and be responsible for that. All again under the rubric and the sort of umbrella of the brokerage, which is the one that has to enter into the contract.
So how would a brokerage choose and implement designated agency?
In order for designated agency to exist, the client, whether they are a buyer or seller, must enter into a written service agreement that lays out the terms of designated agency. Under common law, you can have an agency relationship through written agreement or implied through your actions. Over the years, there has been much controversy about getting buyers to enter into written agreements. Part of the argument has always been that if one brokerage requires written buyer brokerage agreements, another may not, and buyers who don't want to sign one will simply go to the brokerage that does not require such agreements. The Real Estate Council of Alberta is in the process of implementing a change to the rules that will require a written service agreement anytime there is a client representation required for a buyer or seller. The current wording of the rules says industry professionals should have written service agreements. The rule change will say you must enter into written service agreements with all clients. That being said, brokerage policy may vary greatly, and there is a full spectrum of written agreements that can be implemented, depending on the business model of the brokerage. This can be everything from a fully exclusive agreement that includes what fees are to be paid by the buyer, to exclusive and no fees to be paid by the buyer, or non-exclusive, and a buyer can work with as many brokerages as they like. There is also the option of treating a buyer as a customer, which means no agency representation. In residential real estate, open listings are not very common, but in commercial real estate they happen quite often. This practice can continue under designated agency.
So RECA asked an Edmonton broker how he feels about designated agency and the requirement for written service agreements.
With regard to written service agreements becoming mandatory in 2013, and of course the more popular notion of designated agency coming into effect, as a broker I'm really excited for these changes, and I think that it's a fantastic win-win both for consumers and for the industry. I know that my 28 associates have been getting prepared for designated agency and also for written service agreements for quite a while. I see it as a competitive advantage for our industry members, and of course for consumers they can count on actual written agreements, you know, the promises that their associates are making to them about the services that they're going to provide. So it's a fantastic opportunity, and I'm really looking forward to this coming year.
So Doug, do you have any suggestions on how buyer representatives can overcome the objections of buyers to entering into written service agreements?
It's interesting that many people experienced in the industry have objections and find it difficult to get buyers to sign service agreements. But it's interesting to note that brand new practitioners in the industry often have no problems. They simply ask for the order. And one of the techniques that some new people use is they will sit down with a buyer, prospective buyer client, and lay down a copy of a buyer brokerage service agreement along with a buyer customer acknowledgement form. And they'll go through both forms with them in some detail and explain what they can and can't do for them as a client, and what they can and cannot do for them as a customer. And at the end of that explanation, they simply ask the buyer, which would you prefer? And in almost all cases, the buyer says, well, why would I want anything other than to be treated as a client? So they choose to go with the service agreement, and there's no real objection.
So that sounds like an individual industry professional can truly be the sole agent for a buyer or a seller.
Yes, that is the greatest benefit of designated agency model, plus the elimination of attributed knowledge.
Are there other benefits to designated agency, Doug?
One area is the requirement for the written documentation of the relationship. A designated brokerage agreement clearly outlines the relationship between the client, the designated agent, and the brokerage, which increases industry professionalism as well as educating consumers. It enhances client loyalty through the creation of a more formal relationship. It meets the requirements of a written service agreement, and it identifies the obligations of each party. It lessens the concerns that clients will opt to work with the brokerage that doesn't require written service agreements. It supports more buyer representation, and lastly, it reduces the instances of disputes and provides better protection against liability should legal claims be made. Here are a few comments from a broker on how he feels industry professionals will transition to written service agreements.
I think that it's just a matter of people becoming comfortable. I think that, this industry has had an awful lot of changes over the many years the 7 years that I've been involved, even more if you've been involved for longer than that. And it's really just about comfort and developing some skill around it. I don't think it's any different than, sitting down with a seller at a kitchen table and presenting a written service agreement for their listing. They see that as absolutely essential to their business, and that's the mindset they should have about the buyer agency as well. That they're formalizing the relationship and that they're giving them an opportunity to actually demonstrate some value that they're going to add to that transaction. So that buyer counseling session where you present the written service agreement also gives you that opportunity to really enumerate the services that you're going to provide.
Another benefit to designated agency is it eliminates many instances of transaction brokerage, as sellers and buyers can be represented by their own designated agents from within the same brokerage. And in those instances where one industry professional is representing both the buyer and the seller in a transaction, they can act as a facilitator with the written informed consent of the parties. Double ending is still possible. Many believe that we are already practicing that way. Here are a few comments from Brian Taylor.
Under our system of limited dual agency, what limited dual agency says is where you have the brokerage is acting for both the buyer and the seller, the brokerage will treat them impartially and disclose everything to each party except price, motivation, and personal information. Now, when you have a single realtor acting for both parties, that's quite simple. He or she understands they've got two clients. They don't want to favor one of their clients over the other. So they treat them impartially and they make sure the proper disclosures are done except price, motivation, and personal information. However, when you got two realtors in the same office, they don't feel that same sense of impartiality or loyalty. In effect, they only know the seller. They've brought the seller in, they've taken the listing, they've put the listing out there. They feel they're acting in the best interest of the seller, and somebody on the other side of the office may be acting in the best interest of the buyer. Technically, if you think of what our system says it is not those realtors that are acting for each of those parties, it's the brokerage. And so the brokerage is supposed to be treating them impartially, and technically the brokerage isn't. Now, the irony in all this is, somebody would say, well, isn't that a real problem? But the irony, I think, is that buyers and sellers actually like this system. I think buyers and sellers would be appalled if we said to them, oh, we have to tell the other side everything that you tell us except price, motivation, and personal information. They're quite comfortable with an individual realtor being their realtor, maintaining their confidentiality, disclosing to them, acting in their best interest. They don't have a problem with another realtor in the same office acting on the other side of the transaction.
So does the Real Estate Council of Alberta have a preference as to which agency model or brokerage practices?
Council believes that every brokerage should be able to choose the agency model that best suits their business. Council is of the position that designated agency is not appropriate for all brokerages. Some examples would be 1 or 2 person brokerages or small brokerages in very rural locations. The main reason for this is that it may not be possible to put the necessary barriers in place in practice to achieve designated agency. Council will, however, be ensuring that the practice and documentation of a brokerage reflects the agency model they have chosen. RECA will monitor this through its normal trust assurance and practice review programs, including reviewing this issue anytime a professional conduct review is initiated.
Doug, you spoke earlier of conflicts that arise or exist when transaction brokerage takes place. Does Council have any idea how often that occurs?
RECA looked at statistics for the Calgary and Edmonton real estate boards, which represent the majority of residential transactions in Alberta. The statistics from the MLS for 2011 show that just over 23% of all transactions involved a dual agency conflict. Of the total, 10% involved 2 industry professionals from the same brokerage, and 13.5% were situations where only 1 industry professional was involved. RECA believes that the instances of dual agency conflicts is even higher in smaller markets.
Of course. How does designated agency resolve the conflicts that arise in common law transaction brokerage?
Let's take a look at the chart that shows the various types of transactions that can take place. In the vast majority of cases, a transaction involves buyers and sellers being represented by 2 different brokerages, so there is no conflict. This is the same in common law and designated agency. When a transaction involves 2 industry professionals representing the buyer and seller within a brokerage under common law, there is an agency conflict, and transaction brokerage would be offered. The same situation under designated agency would not be a conflict, as the buyer and seller would each be represented by their own designated agent and continue to have sole agency. In a situation where an agency professional has both the buyer and the seller as a client in the same transaction, there is an agency conflict under both common law and designated agency. One of the benefits of designated agency is that either the seller or buyer can be referred to another designated agent at the same brokerage, and the transaction can continue with sole representation of each client. This is not possible under the common law model, as the options are for the client to agree to be treated as a customer or referred to another brokerage. The last situation is where 1 industry professional provides services to a client and a customer in the same transaction. There is no agency conflict under either agency model in this situation.
Before we move on, Doug, could you sum up the key benefits of designated agency?
There are 5 key points. The relationships under designated agency are consistent with consumer expectations. It may be consistent with current practice in common law brokerages. Requiring written service agreements promotes a clear understanding of the role of the industry professional. It reduces the potential for conflicts of interest arising from concurrent representation, meaning 2 associates or associate brokers from the same brokerage. And it eliminates attribution of knowledge between industry professionals within the brokerage.
RECA asked a couple of brokers how they feel designated agency might impact professionalism. Here are their comments.
Well, when I think of designated agency, I think a lot about really clearly explaining and putting your buyer into a buyer's brokerage agreement, and for me that's a big component of it. And I think that having that sit down, that face time, making sure that they understand the relationship and knowing that that relationship won't change the whole way through, that you don't have to now try to explain to them about the circumstance of if we get into transaction brokerage and what does that look like. So I think that it simplifies the process, and it really is the way that, unfortunately, most of us are functioning now, even though we're technically not supposed to be doing.
I think that if people are held to a higher standard because they've had to identify that standard at the onset of the relationship, that people will feel more accountable. The clients will see the accountability from their associate, and they'll be able to have those conversations, which I think unfortunately don't happen a lot of the time as it exists now. You get the call from your client, a week after, you met with them last, and they're so excited because they bought a house, but they didn't buy it with you because you never formalized that relationship with them. So client loyalty will absolutely be increased for the industry.
So Doug, what is the most significant change in practice for industry professionals switching to designated agency?
The biggest change is the requirement for written service agreements with buyers. Here are a few comments from an associate who has gone through this change to designated agency.
I think the most significant change in our practice was all of us being on the same designated agency agreements. Understanding that we are one as a team and that we understand each of the needs of our clients, and having that separated and having somebody else come in to represent either the seller or the buyer, that was probably the biggest change. The physical location, office space, and some of the other requirements for the designated agency model, that wasn't a big deal for us. That was something that we were heading towards anyways. Really, the change to designated agency made a whole heck of a lot of sense for both the brokerage and for us as a team. And I know that there were a lot of people that were confused, a lot of people had concerns going into this. It was easy, it was seamless, it was a transition that we were all really happy with when it was done.
Congratulations, you've now finished 2/3 of our refresher course. I'm going to pause again here for a moment, allow you to take the quiz, and please remember at the end of the quiz we have an email link to RECA to answer any questions that might have come up.